Hi, good morning to all. Recently, Government of India has introduced a landmark reforms in labor laws, namely labor codes. And it is the most significant policy reforms in independent India. New labor codes aims not only to protect the interests of the workers, but also simplify the business operations to accelerate economic growth, and more importantly, to empower HR professionals to become a true strategic partner in the nation building. For many decades, India's labor ecosystem was governed by different laws created at different times for different purposes with different definitions. Truly speaking, operating a company with this many independent and divergent acts was definitely a Herculean task, and confusion of the provisions was very high. So it is very difficult to navigate effectively and efficiently with these divergent definitions and provisions of labor laws. Every HR professionals find it difficult to understand all the provisions of the law. Then just imagine what will be the condition of a businessman. The new labor codes exactly aims to simplify the provisions of the labor acts and bring ease of doing business. The four labor codes brings common definitions of workers and wages, and more importantly, only single registration, single license, and of course, single return. The four labor codes brings common definitions of wages, workers, etc. Of course, digitalized compliance and e-inspection. Change, even if it is good, brings a lot of confusion and fear to all the stakeholders. These are the four labor codes aims to bring ease of doing business without compromising the rights and privileges of the workers. These changes calls for more awareness among all stakeholders. So let us dive deep into the provisions of labor codes. These reforms brings reduce unnecessary paperwork and allow the employer to concentrate on the business, innovation, and expansion rather than the compliance complexity. When the compliance become transparent, the trust grows. When the HR professionals become the strategic partner, the institution grows. When the institution grows, the employer grows. When the employer grows, employment grows. When the employment grows, the employees grows. So it is a win-win situation for all, including the common man. So let us see the details of four labor codes. Today we will be discussing the background and the need for labor law. Then we will overview the four labor codes. Then we will discuss key provisions of all the four codes. Subsequently, we'll discuss the pre and post implementation comparison. Then we will discuss in details what are the changes made in the 29 labor laws. Then subsequently, we will discuss the financial implications for the employers, then how it will affect the organization to work. Then what are the benefits to the employers and what are the benefits to the employees? Then, of course, challenges and way forward. Labor laws are in the concurrent list. That means the central government as well as the state government can enact law as per their requirement. At present, 44 central acts are available. This central government has enacted 44 labor laws, and in Kerala state, 150 acts are existing now. So just imagine how difficult the compliance will be for the employer and the organization. After the independence, there was no major labor law reforms during the 79-80 years. The present labor codes is the outcome of the suggestions or recommendation of the Second National Commission of Labor, constituted on 15th October 1999. The first commission is known as Royal Commission on Labor, constituted on 1926. So after around 75 years only, the Second National Commission of Labor was constituted. The chairman of the Second National Commission of Labor is Ravindra Verma. The key reference for the commission to give the recommendation were, number one, consolidation of labor laws. All these 44 laws, whether it is required to maintain all these 44 laws or not. Then, second one was any amendment required in the laws. Third one, how to extend the benefits to the unorganized sector. As you know that around 90% of the workers are in the unorganized sector and they are not covered in the labor laws. So these were the three reference points given to the Second National Commission of Labor. The commission submitted the report on 29th June 2002. After 3 years, they submitted the report. Their main recommendation was to reduce the multiplicity of labor laws and to codify all these laws into 4 or 5 codes. After around 20 years, the government has passed these codes in 2019 and 2020. Still, it was not finally notified. And on 21st November 2025, the government was notified the 4 labor codes to be effective from 21st November 2025. So, all these 44 acts were codified, consolidated into 4 codes. So, out of these 44 labor codes, 12 acts have been repealed. That means they have withdrawn. And 29 labor acts were subsumed into 4 labor codes. So, it is quite natural to ask that 29 are subsumed, then 12 are been repealed, then where are the 3? Yes, these 3 acts were not relevant at all. So, it was not considered. So, in nutshell, only 29 acts are subsumed into these 4 codes. The 4 codes are Code on Wages, 2019. It has included 4 acts of central government. Industrial Relations Code 2020, 3 laws are covered in that one. In Social Security Code 2020, 9 acts are included. Then 4th one is Occupational Safety, Health and Working Conditions Code 2020. That is 13 acts are included in that. Okay, let us move forward. Earlier, 44 acts were available. Now it is 4 codes are. So quite naturally, you will have the question, what is the difference between act and code? Act is a specific piece of legislation that addresses particular issues or areas enacted by a legislative body. Act focus on specific legal provisions. For example, Right to Information Act 2005, Companies Act 2013, Employees Compensation Act 1923. So in Employees Compensation Act, it will cover only the employees' compensation only. Or if it is the Payment of Gratuity Act, it will talk about only about the Payment of Gratuity Act. Whereas in the code, let us see the difference in the code. Code is a comprehensive collection of laws governing a broad area of law, systematically organized. Codes provide a detailed framework for legal principles. For example, Insolvency and Bankruptcy Code 2016, the Indian Penal Code, commonly known as IPC 1860, Indian Civil Defense Code 2023. So code means it will be a broad area will be covered, whereas in the act, it will be only a specific area will be covered. That is the difference between act and code. Some of the acts were more than 100 years old. Trade Union Act was passed in the year 1926. Even Employees Compensation Act Earlier, it was known as Workers' Compensation Act. It was implemented into 1923. Subsequently, it was changed to Employees' Compensation Act. So, almost 100 years completed now. Then only we are coming with these new reforms in the labor laws. Recently, the number of contract laborers has also increased. Now, almost all the organizations, the private as well as the central government, they concentrate on engaging the contract labor rather than the permanent employees. Why the code was required? Let us see from the employer's perspective. Because number of labor laws, legislations were there, so it was very confusing for the businessman to understand it. Second one is excessive inspector ranks. Yes, it is abolition of inspector ranks. Earlier, the condition was that one day labor enforcement officer will come for inspection, another day factory inspector will come, then employment exchange officer will be coming another day, or PF inspector will be coming. Sometimes the labor inspector will come. So it was very difficult to manage the inspectors. There was no routine also. Whenever they want, they will come to the organization and ask for the documents. No one can deny it. So it was a terror for the establishment to manage it. If they want to find out a problem in your organization, definitely they will find out. The very purpose of the inspection is very good. But the problem is that the inspector comes with a personal purpose, and unless you meet that personal purpose, they will not leave you. Penalty or notice will be issued to you. So it was a terror for the employer. Then definitely plethora of forms and registers to be maintained. It was not so easy. Then numerous returns to file in different intervals. Let us move forward. Why the code was required? Let us see from the employee's perspective. The regional disparity in the minimum wages. Can you imagine? The minimum wages prescribed by the state governments vary from state to state. I can tell you one example. I was working with NSPC. It is a central government PSU. So the appropriate government is the central government. So the minimum wage will be applicable as per the minimum wage prescribed by the central government. Then, when I was on deputation to another one subsidiary, Chenab Valley Power Projects Limited, as a CHRO at Jammu. In Jammu and Kashmir, Kiswar is the one district where majority of the hydro projects were established. At the same place itself, power stations of NSPC as well as the Chenab Valley Power Projects are existing at side by side. So, NSPC contract laborers, being a central government minimum wages applicable, they were getting higher wages. When we compare the minimum wages of state government and the central government, we can see the central government minimum wages are much higher than that of the state government. So, Chenab Valley Power Projects employees, contract laborers, they were getting very less wages. So, whenever they get an opportunity, they will switch to NSPC projects. So, the Chenab Valley projects were just training the employees, laborers, and once they get trained, they will move to NSPC projects. So we are finding it very difficult to manage it. Another aspect is that the government has prescribed minimum wages. That doesn't mean that we cannot give more than the minimum wages. Because of all these problems, in Chenab Valley Power Projects, we approached the board of directors with a new suggestion to increase the minimum wages. In a balanced way, what we did was, we adopted, there was a J&K government standard rates. It is higher than the minimum wages of the state government. So we approached the board of directors and suggested to increase the minimum wages to JKSR rate, which was almost equal or just less than the central government minimum wages. So once we implemented this migration of labor from Chenab Valley projects to NSPC was curtailed and stopped. Some of the practical solutions we had to find out to stop such problems. The 4 codes in detail we can discuss it. The Code on Wages consolidated 4 laws. It is the Minimum Wages Act 1948, Payment of Wages Act 1936, Equal Remuneration Act 1976, Payment of Bonus Act 1965. In these 4 codes, the definition of wages, workers, etc. was created uniformly. Minimum wages, everything it was uniformly created. And timely payment also was prescribed in the wages code. Then comes to the Industrial Relations Code. 4 acts were consolidated. One is the Trade Union Act 1926, Industrial Employment Standing Orders Act 1946, Industrial Dispute Act 1947. It simplifies the dispute resolution, promotes industrial harmony, and improves business environment, ease of doing business. Then comes the Social Security Code. It has consolidated 9 acts. They are Employees Provident Fund Act, Employees State Insurance Act, Employees Compensation Act, Building and Other Construction Workers Cess Act, Payment of Gratuity Act, Maternity Benefit Act, Unorganized Workers Social Security Act, Employment Exchange Act. It extends Social Security to unorganized sector, gig and platform workers also. As we discussed earlier, only the scheduled employment, even though number of laborers were engaged by different companies, only scheduled employment was covered in all these acts. Then gig workers, that is a subsequent developments. Because of the acts were not modified, so these gig workers and platform workers were not covered in the labor acts. So this Social Security Code cover gig workers and platform workers. Let us move forward. Next one is the Occupational Safety, Health and Working Conditions Code 2020. This act consolidated 13 laws. This is mainly including workplace safety and working conditions, Contract Labor Regulation and Abolition Act, Factories Act, Mines Act, BOCW, Building and Other Construction Workers Act. So you must have seen in Social Security also, BOC, Building and Other Construction Workers Cess Act was that one. Here it is Building and Other Construction Workers Act. So this was only in the same area, except 2 acts were there. So it was very difficult to manage it. Then Interstate Migration Workers Act, etc. These acts provided for single registration, common licenses, health and safety standards across all sectors. Okay, let us move forward. Here you can see the magnitude of the simplification effect. Out of these 44 acts, around 1,228 sections were there. Now it has been reduced to 480. In these acts, 1,436 rules were there. It has brought down to 351. See the difference in registrations. Earlier, 8 registrations were required. Now it is only 1 registration is required. That is also applicable all over India. Then licenses, earlier it was 4, it was required. Now it is only 1 required. 181 forms were required to be submitted. Now it is only 73 forms are required. Registers, earlier it was 84 registers were required. Now it is only 8. 31 returns were required. Now it is only 1 return. Just imagine how simplified it is. Similarly, decriminalization. Around 87 sections were covered for imprisonment. Very daring, very difficult, very terrorizing time. These inspectors were using all these tactics. Then now it has brought down to 22. Another one main modification has been made is the compounding of penalty. We will discuss it subsequently. Okay. Let us have a pre and post comparison of these acts and the labor codes. Earlier, there was no formal employment order. Now it has become mandatory to all the workers. Now it is security of employment is given, guaranteed. Earlier, it was just a verbal commitment was there. Now it is a written proof, and transparency and job security also will be there. Earlier, social security coverage was not there. Now it is under Code on Social Security 2020. All workers, including gig and platform workers are covered for social security coverage. Minimum wages, as I discussed earlier, minimum wages were applied only to scheduled industries and employments. Large sections of workers were remain uncovered. Unorganized sector, gig workers, and platform workers were not covered. Under the code, all workers to receive statutory right of minimum wages. Now, concept of floor wage has also been introduced, reducing the wage disparity across states and promoting standard of living. Preventive health care. Earlier, it was legal, it was not covered. Now, employees must provide all workers with a free annual health checkup. It is sooner they reach the age of 40, it has become compulsory. Let us move forward. Timely wages. Earlier, it was the wages were disbursed by 7th or 10th. When the contract labor is more than 10,000, then the wages can be released up to 10th. When the contract labor is less than 1,000, then by 7th it has to be released. Now it is by 7th itself. For all the establishments, it has to be released by 7th of the next month. And in the case of exit, that means retrenchment, resignation, termination, in all these cases, the terminal dues has to be released within 2 days. Earlier, women participation in the work was very limited. Female employees in the night shifts and certain occupations were prohibited. Now, women are permitted to work at night with their consent only, of course, and in all types of work across all establishments subject to their consent and required safety measures. Now, earlier, because the night shift and some of the work were highly paid, but the women employees were not permitted to join in that work. Now, women will get equal opportunities to earn higher income in higher paying job roles. ESI coverage. Earlier, ESI, Employees State Insurance Corporation, it was much beneficial for the medical benefits and a number of other benefits also. It was covered only to the notified areas and specified industries only, not all the establishments. And secondly, whenever the employee's strength is more than 10, then only it was applicable. So if it is less than that one, even if the employer wants or the employees wants, it was not allowed to join in the avail the benefits of Employees State Insurance Act. Now, ESI coverage and benefits extended to pan-India. Voluntarily, even the number of workers are less than 10, voluntarily the establishment can join the ESI and give the benefits to employees. And it is mandatory for establishment with even one employee engaged in hazardous process. Earlier it was not there, now it is compulsory. So social protection coverage will be extended to all the workers. The compliance burden. Multiple registrations, license and returns across various labor laws. Now it is single registration pan-India, single licenses and single return. Simplified process and reduction in the compliance burden. So let us move forward. Other changes. Now the worker threshold for retrenchment, layoff and closure has increased from 100 to 300. Earlier, when the labor is more than 100, then only permission was required to retrench or close the establishment. Now it has been increased to 300. The second one is union negotiation. Earlier it was compulsory to discuss with all the unions. Now, when the union strength is more than 51%, then that will be considered as a negotiation union. If none of the union is having 51% of membership, then it will be negotiating council. So, all the unions having more than 20% of workers will be considered as a negotiating, will be included in the negotiating council, and the wage negotiation, all the negotiations will be taking place. Earlier, it was not the condition. Just imagine in NSPC where I was working, around 37 unions were there in all over the projects. So how difficult it was to negotiate even if you want to increase the salary, even if you want to give benefits, even if you want to discuss, we have to call all the 37 unions to the table and find out a solution. So very difficult. Now it is maximum 5 unions, not 5, even only 4 unions can be there in the negotiation council, because 20%, more than 20% has to be maintained in the membership. So maximum 5 unions will be there in the negotiating council. Then industrial tribunal with 2 members. Earlier it was a single member of judicial member. Now it is 1 judicial member and 1 administrative member. It has become more practical because judicial administrative member will understand what is a practical problem. So a balanced decision and quick decision will be possible by introducing the 2-member industrial tribunal. Now mandatory 14-day strike notice for all the establishments. Earlier, at any point, as per the mood of the unions, they can go for the flash strike. It was very difficult to manage it. Only in public utility service like electricity, water supply, only these such places, only 14 days notice was required. Otherwise, it was not required. I can tell you, in one of the construction projects of NSPC, all of a sudden they have called for the strike. Even for constructing a dam, the complete water was taken out. That area was kept dry, and the concrete was getting mixed. So all of a sudden, the laborers they went on strike, and it was jammed. The concrete mixing machine was jammed. It was heavy loss to the organization. So now giving these 14 months, this is a benefit for the employees also, because the time cures. When they get that time, their temper will come down, and they will understand the problem very easily. So it is good for the employees as well as for the employer. Now, worker threshold for applicability of the Factories Act has increased from 10 to 20 with the power. Earlier it was the factory is working with the power. If the worker is more than 10, then license was required. Now it is 20. Earlier, without power, the factory is working. Workers' requirement was 20. Now it has increased to 40. Another one is allowing the women to work at night shifts. Then increasing the overtime hours to 144 hours. Earlier it was only 52 hours in a quarter. So it is in a way the labor will be benefited because they will be able to do extra overtime. Extra overtime means it is a double wages. So they will be getting more wages. Earlier it was only 52. 52 means around 15 to 18 hours in a month. Now they will be getting 144 hours per quarter. Now 1 day leave is a compulsory. If a labor has worked for 180 days, 1 day leave for every 20 days has to be given. Earlier it was after 1 year only. So let us move forward. Other changes. Worker threshold for applicability of Act increased from 20 to 50. Contract Labor Regulation and Abolition Act, it was 20. Now it has increased to 50. The fixed term employment rules have changed. It has been introduced. This is very useful because if an organization wants to engage some workers for a particular period for some urgent work, they can engage FTB. In private companies, still it may be possible. Whereas in the central government as well as the PSUs, once we engage, we cannot remove them. Even if it is for engage for 1 year, 5 years, 10 years, we cannot remove them. Now this fixed term employment has allowed us to engage fixed term employees for 1, 2, even any number. There is no upper limit also. But the another advantage is that all the benefits has to be given to the fixed term benefit employees also. Earlier it was not there. Now even for gratuity also. Earlier it was after 5 years only they were eligible. Now after 1 year, these fixed term employees will be eligible for gratuity payment. Now all the allowances, whatever the regular employees are getting, the same benefits has to be given to the fixed term employees also. I can tell you in central government PSUs, the number of components are there. The basic pay, DA, cafeteria allowance, PRP, or number of other allowances also. Leave, then gratuity payments, PF, number of things are there. Now it has to be extended to all the fixed time employees also. Another one is the compounding of offenses. Earlier it was imprisonment, means it was not possible to convert into the penalty. Now it is for 5 years. An establishment will be allowed to compound the imprisonment penalty into make the payment of penalty. So some terror has been reduced. The mode of payment has been defined now. It has to be paid to the bank account. Earlier it was cash only. So it was very difficult to control it. Now it is a proof that the payment has to be made to the employee's account itself. Registers only 2. Earlier it was 10. Returns only 1. Earlier it was 4. Registration only 1. Earlier for every act the registration was required. Let us see the benefits of labor codes. The main benefit is the uniform definition of workers, wages, everything. Now another advantage is that leveraging of technology, electronic forms, registers, and e-returns. Then another one is the transparency in enforcement. Now it is not an inspector. Now it is inspector come facilitator. It is his role is not for inspect alone. He has to facilitate the organization how to implement the laws and how to give the benefits to the employees. So it is a dual role will be given to the inspectors now. It is a randomized web-based inspection system. This is the most important benefit to the employer. Earlier it was any inspector can decide where he has to inspect it. If he want to visit some place, he will go to that place and inspect all the establishments around that area. And if he want to get some benefits, he will visit that place. Now it is not like that. It will be web system. Online it will be decided which are the establishment, when it has to be inspected, by whom. So inspector cannot decide it where he want to inspect it. Now that pick and choose policy is removed altogether. Now higher female labor force participation. Right to work in all roles, work at night shift with their consent. Crèche facility in establishments having 50 or more employees. So benefits to the employees. Number 1, statutory right for minimum wages extended to all employees. Then timely payment of wages, including electronic transfer. Statutory floor wages has been introduced. The another advantage is that the allowances exceeding 50% made as part of the wages. Earlier it was not that one. Basic pay will be less, allowance will be more. Now, allowances cannot be more than 50%. So wage automatically it will increase. So the contribution from the employer towards the employees on account of maternity benefit, gratuity, EPF, employees provident fund, employees pension scheme, etc. will increase. It is a benefit to the employees. So the 50% wage rule, let us see in detail. The wage includes basic pay, dearness allowance, retaining allowance, etc. Specific exclusions are statutory bonuses, overtime, HRA, employees provident fund, conveyance allowance, special allowance, commission. Now wages must be at least 50% of the total CTC. 50% is the wages, 50% will be the allowances. No, we cannot increase allowances more than 50%. So the gig workers, they were not covered. Even the platform workers. Gig workers are temporary and freelance workers. They were not covered. Whereas the platform workers are those who are, actually you can understand these Amazon, Flipkart, Zomato, all these delivery boys, they are the platform workers. They were not covered in all the acts. So let us move forward. So this 50% wage rule, let us discuss in detail how it is working. It will work. So with the example, we will illustrate it. The total remuneration is 60,000. So how it is distributed, just with an example, we will discuss it. Basic pay is 20,000. DA is 5,000. HRA is 15,000. Conveyance is 2,000. Special allowance 16,000. Bonus 2,000. So this total remuneration is 60,000. So let us check how this 50% rule will work. The inclusion part, this is a basic pay. It is shown in the red color. Basic pay and DA are covered in the wages, basic wages. That means 25,000, 20,000 plus 5,000 is 25,000 is the basic wages in this one. The exclusions are HRA, conveyance, special allowance, and bonus. So here in the present example, the HRA is 15,000, conveyance is 2,000, special allowance is 16,000, and bonus is 2,000. This is included in the allowances. So it comes to 35,000, whereas the wages is 25,000 only. It is almost all 58% remuneration. So the calculation is that as per the new code, minimum wage has to be 30,000. That means 50% of the total salary. That is, total is 60,000, 50% is 30,000. So what we are giving as allowances is 35,000. So above 50%, which has to be put back to the wages. That means 35,000 minus 30,000 is a 5,000. This has to be included into the wages. That means final wages will be 25,000 plus 5,000 is a 30,000, and the allowances will be 30,000. So all the benefits, just like that of ESI, Provident Fund, gratuity, all these allowances, the contribution from the employer will have to be made on the base of the final wages of 30,000. It is a much benefit. Some of the employers were exploiting the workers by reducing the wages and increasing the allowances. So let us move forward. See the financial implications for employers. It is quite natural. There's a change is there. Definitely some financial implication will be there for the employer. As discussed in the previous slide, the minimum wage will increase it because the burden on the Provident Fund contribution, ESI contribution, everything will increase now. Now, another one is the reskilling fund on retrenchment. 14 days wages has to be given or in the case of retrenchment to the labor. Earlier it was not. Pre-annual medical checkup. After attaining the age of 40 years, pre-medical checkup has to be ensured by the employer. The financial cost will increase. The wages must be 50% of the total CTC. So, additional contribution on basic pay, EPF, EPS, gratuity, ESI, maternity benefit, etc. So, simultaneously, the employers are getting many benefits also. Now, ease of maintaining records. So, it is limited number of records are reviewed. Even online, it is possible to maintain it. Nowadays, all young laborers, your employers also tech savvy. For them to maintain the records on computer, it will be very easy. Less fees, faster adjudication. Then, in the case of EPF appeal, earlier, once the court has decided, 75% of the amount has to be deposited, then only they can go for the appeal. Now, it has been brought down to 25%. If it is 1 lakh is a penalty is issued, then only 25% have been deposited, then you can go for the appeals. Then definitely compounding of punishment. Imprisonment can be escaped from that one by paying in cash itself. That is only once in 5 years. If the same repetition is there, it will not be allowed. Let us see other benefits to employees. Ease of compliance under Employees Provident Fund Act. Limitation period of 5 years for inquiry in the past cases. Earlier it was pre-independence period also they were allowed to open it. Now it is only 5 years. Assessment audits within 2 years it has to be issued. Otherwise it is suo moto, it is considered as issued. Power to reopen cases on suo moto basis abolished. No, it will be web-based system will be there. EPF appeals. I already discussed that 75% instead of 75%, only 25% has to be deposited. So let us see the other benefits to the employees. Universalization of social security. Gig workers and platform workers are covered. Unorganized workers are covered. ESI coverage to all establishments. Earlier it was limited only. Certified only to the areas notified under the notified industries only. Even the threshold of workers' requirement was 10. Now it is less than that one also. Voluntary also can be done. Provisions for increased participation of women workers. Work from home option after maternity leave. Mandatory creche facility for establishment with 50 or more employees. Again, moving forward. Benefits to employers under occupational safety, health, and working conditions. The threshold has increased for contract labor from 20 to 50 workers. Factories with power, 10 to 20 workers. Factories without power, it has increased from 20 to 40 workers. Simplified compliance. Single All India license valid for 5 years. Deemed approval and renewal of licenses. License automatically, if it is applied and if it is not approved within the specified time, it will be deemed approval and they can proceed further. And another most important is the third-party certification for startups and class of establishments. This inspector is not required for third-party. Let us see what is the third-party certification of startups. A new scheme has been introduced where the qualified experts conduct the independent audits to ensure an establishment's compliance and with their labor laws, which can allow them to avoid routine inspections. The certification is typically issued by the qualified and independent third-party accredited agencies, such as an agency accredited by the Director General of Factories Advice Service and Labor Institutes. So it is not that any Tom and Harry can inspect it. No, it has to be the agency specified for this purpose. It will support the startup ecosystem by making compliance more manageable. So no inspection is required if the third-party certification is done. This will be sufficient and no inspection from the inspectors will be there. It will facilitate the startups and small establishments. What are the benefits to employees? One is the formalization of employment through appointment letters, pre-annual health checkups after reaching the age of 40 years. Interstate migrant workers includes directly employed or through contractors. Earlier it was only direct employment only. Universal occupational safety and health. National standards for health and safety will be ensured. Welfare facilities, canteen, medical, etc. will be extended. Okay. So let us see the benefits to the employees as well as the employers. Fixed term employment. No limits on sectors, periods, tenures, and employees. Workers get same benefits as permanent staff. So it is beneficial to both the parties. Raise the threshold for retrenchment, layoff, and closure from 100 to 300 workers in factories. This will help more employment will be created when the threshold is increased. So it is beneficial to the employees. Definitely it will be beneficial to the employers also. Statutory negotiating union council. So any time the strike is not possible. Flash strike especially is not possible. So some of the avoidable disputes can be sorted out by discussing or sitting over the table. So no need of creating disharmony among the employer and employees. Faster adjudication of disputes because two-member tribunal, one is a judicial member and another one is administrative member. Reskilling fund for retrenched workers, 15 days benefits for each worker. Mandatory 14 days strike notice. It is beneficial to both the parties. Reskilling fund, definitely it is beneficial to the employees only. It is not beneficial to the employer. Moving forward, challenges and way forward. One is a delay in final notification of state and central by the central government. Because till now, even though the act is applicable from 21st November 25 onwards, till the notification is issued, the procedures are not specified. So the government, central government as well as the state government, will collect the suggestions and objections and issue the final notification. Lack of clarity on wage definition. Still some confusion will be there, but it will be sorted out. Because this categorization of 50%, it is not known to all. Increased compliance burden initially. Number of new records, new systems, no procedures, everything will be new. Financial impact on employers. Any change in the system will attract more financial burden on the employers in the form of creating new records, in the form of third-party inspection. So financial implication may increase. Definitely, there will be a resistance from the trade unions because they fear their right to strike at any moment. Administrative capacity of the labor departments have to be increased because the change is very huge. Digital readiness, it is a challenge for employers as well as for the employees, for the labor departments also. Moving ahead, challenges already we discussed. So let us revise what we discussed today. Background, need of the labor system. We discussed it, how it was generated. The Labor Commission was National Labor Commission was formulated. They suggested it, then codified it. Overview of the 4 labor codes. All the labor codes we discussed in detail. Key provisions of each code. We made a comparison of what was previous. Now, after the implementation, what are the changes are taking place? Major changes in the previous 29 laws. Financial implication for employers, benefit to employees and benefit to employers, challenges and way forward. Compressing all these 44 acts into 4 codes, it was very difficult. Similarly, all these acts, all the provisions, all the benefits, all the changes has to be discussed at short notice. It is not so easy, but still I try to complete all these provisions as simple as possible so that you can understand and you can move forward very easily. So, thank you to all. We will see later on in another one episode. Thank you very much.